If Mr. Rebar wishes to turn on the camera, have it at me, collect me and the voices of the parties, that can happen. So if you want to set that up and point it at me, feel free.
But I've got multiple tools. I've got a professional camera. Tripod and other tools to professionally record and document and disseminate information.
You wanna play tough and wanna hate this, I'll always show up and make a statement.
Normally, if you're in this building or one just like it, a court building, you're not having a very good day. Today's story is a celebration of something that happened in court. I know how difficult court videos can be to watch. I've heavily edited this one, the parts where the judges are looking at the law and they take 15 seconds to take a thought before they answer something. I cut out all those 15 seconds and we just get to the conversation as it happens back and forth. None of the conversation was cut out, just the dead space so that it's more tolerable to watch. I think it's important to watch court videos even when they're boring because you need to learn the lingo that these people use when they're litigating. This is how they think and how they talk, and we need to become familiar with it so that we can present an argument in their language that they can understand. Now, even though it took this judge 45 minutes of thinking about it, he eventually did come to the right conclusion and allow this guy to pull his camera out.
Mr. Rebar's made the request for the ability to have electronic coverage.
Do I get a chance to respond to that, sir?
Hang on a second. The rule talks about news reporters, and that's the normal context this comes up in. And news reporter in 229 is defined as any person who gathers, prepares, collects, photographs, records, writes, edits, reports, or publishes news or information that concerns local, national, or international events or other matters of public interest for dissemination to the public. I guess as a preliminary matter, Mr. Rebar, are you a reporter?
He needs to read that definition a few more times.
I am. I publish videos of government interactions. I have close to 100 videos published. The videos that have Deputy Bueno in them have received over 100,000 views. There is public interest in this case. Just before coming in here, I was outside doing a YouTube live video. There were 250 people watching. So there is public interest in this case. The information is disseminated to the public for them to judge and what their government is doing so that they can make better decisions about their votes in the future.
You've used Mr. Bueno's application as an example. Is your reporting limited to this case?
No. I started with a brief history. I started with the Nevada DMV when they ordered the seizure of my documents without any reasonable suspicion and took my papers. And the Nevada DMV had created regulations as defined under NRS 233B-038 without any due process of the Administrative Procedures Act. And they started enforcing those laws under the color of law with guns and badges without ever having done any public meetings, without ever having gathered any information from the stakeholders and the businesses as required under 233B to implement a new regulation. And they did that for 2 years. And then when I questioned DMV Director Julie Butler, I've published a lot of different things, whether it's Deputy Bueno, Highway Patrol Troopers, DMV Director, the Chief of DMV Breaking the Law, government actors. He's not the only government actor that I'm publishing information about. I'll publish information about any government actor.
Thank you. Mr. Bueno, I do note the irony somewhat, might not be the best term, the request to record when the underlying issue in part might be the recording and dissemination that are in the allegations. It's not lost on me, but as far as responding to his request to have it recorded, what are your thoughts?
Mr. Rebar is not a journalist. The contents of the videos that he's presenting constitute a Category C felony of aggravated stalking and harassment against myself. There's a criminal case that's being filed on that matter this week. He heavily edits videos in his favor, and he makes money off of those videos on the internet to curry social favor and status as well as financial. I believe that another reason for him to try to introduce cameras is so that he can edit and sway more public opinion, which in turn is damaging myself and my family.
In a second, I was making a note.
Additionally, Your
Hang on
Honor,
a second. I had 2 points I wanted to write down. Challenging his status as a reporter, the editing. One of your other main points, if you could please restate it.
he's monetizing these videos. He's mixing them around in order to produce libel, which is not covered under the First Amendment, as you're well aware. Publishing that on a public forum.
What was the point that you were then going to get to?
Sorry?
What was the point you were going to get to before I asked that question? You had something else you were starting to say.
Just the fact that he's using the journalism tact in order to commit gross misdemeanor and Category C felonies against myself. My thought on him having the camera in the courtroom would be to further his stalking and harassment of myself and my family.
It's interesting to see all of the things that the deputy tries to use to get him to not record in court. They make absolutely no sense. But these are things that get argued in court. Watching videos like this can help you be prepared for those arguments against you when you're trying to be allowed to record your own stuff in court.
And knowing that this is being recorded by the court already, and that he could ask for a copy of that, how does that impact your analysis, if at all?
My concern would be his heavy editing that he's known for, editing all content of either sheriff's office recorded videos or others to sway and basically whip up attention to his case, which he monetizes.
And if he did get a copy of the courts digitally, he could still edit, I assume.
I'm not sure procedurally how that works. Obviously, my attorneys would be aware of him editing those and publishing those, so I'm not sure exactly how him receiving that would be a conflict, in my opinion. Obviously, it's public record, but he has a history very well documented of what he's doing with the content of his videos now, as well as public record videos that he's obtained from the sheriff's office.
Let me get this straight. You don't mind him having a full recording of the proceeding. You just don't want him to be allowed to record it on his own device. Does that make any sense at all?
If he were allowed to record, I'm looking at the statutory factors or the rule factors. Impact on the right of a party to a fair trial, right of privacy of any party or witness, impact upon safety and well-being of any witness or juror, or the likelihood that the coverage would distract the participants or detract from the dignity of the proceedings. Any comment on those? I know I listed a lot.
Specifically the stalking, NRS 200-575, and then obviously subsection 1, which outlines without lawful authority, willfully, maliciously engages in a course of conduct.
Right, but hang on. We're just talking about this particular hearing, not whether there was stalking, not the underlying allegations. For the purposes of this hearing, let me just slow down a little. Do you think that this hearing would inhibit either party's ability to get a fair trial? Would it inhibit you some way or me some way? Obviously he wants it, so I don't assume it wouldn't inhibit him.
I believe his intended use is to sway as much opinion as possible to curry his favor. I believe that he would post those videos, which would in turn create more threats that I'm receiving daily. I believe that's what his intention is.
What about the impact? Does coverage upon the right of privacy or any party or witness, any privacy concerns?
I do. Privacy is obviously a concern as it's been violated as a result of his actions. And I do apologize that we're double hearing aids.
I'll speak up. I tend to speak quietly. Is that better?
I should have said that before. Yes, sir.
I'll speak up. Any comments upon if he's simply allowed to record the impact upon the safety and well-being of any party or witness, you or any witness?
Yes, sir.
What's your thoughts on safety if he's recording you?
The safety issues that I would be concerned about, which began the situation, is the doxing. where he's publicly producing information related to me. My family members have been contacted. Locations of my children's schools have been revealed, all instituting a threat that's been initiated by Mr. Rebar's unlawful actions. Again, the privacy would be of concern. To release more information subject to this case, I believe, would damage and create more of a safety risk for my family as well.
Part D, likelihood that any coverage, him recording it, would distract participants, you, or detract from the dignity of these proceedings.
I believe it would.
Why?
I'm sorry?
Why? I mean, how would it be distracting if the camera's sitting there recording?
Because the source of what he's doing with that information and how he is twisting all facets of this case that have been proven through documentation and investigation and through the sheriff's office and the DA's office, he is knowingly, falsely making statements online using these recordings and proceedings and anything else that he makes, which is causing the threats towards myself and family. And I believe that having his camera in here is another intimidation tactic by himself that he is clearly using throughout all of his videos, that he's clearly trying to introduce to the courtroom today under the false pretense that he is a journalist.
You say there's, I think, lots of videos out there. Have you seen any videos where it appears he's in the past received copies from the court and used those or edited those?
I haven't seen the court videos at this time, no. He has recovered the sheriff's office body camera videos under public information requests, and those have been edited and spliced and
Objection, that's not factual.
used for his advantage.
But he's had the ability to get them and post them.
Yes, sir.
You say he's edited them somehow. Mr. Rebar, to you, have you received court or other public recordings and been able to edit them and post them after the events as opposed to just your own live ones?
Yes.
I love how he doesn't hesitate there because he knows he isn't doing anything wrong.
Are you monetizing this stuff?
Just like MSNBC, just like CNN, just like ABC, when people view things are monetized. Just like all of the major media that's existed in this country for a couple of hundred years or across the world, if you want to get old school, has media always been monetized? Have people always paid for newspapers? That's just a historical thing. I don't understand the argument that it's because it's monetized, it's not journalism. The Supreme Court, the courts have, how do you define journalism? Let's get into Article 1, Section 9 of the Nevada Constitution. That's freedom of press, freedom of speech. No law shall be passed to abridge speech or press. We all have freedom of speech in this country, freedom of speech in the state of Nevada under our Nevada Bill of Rights. We all have the ability to be members of a free press, whether it's you, Your Honor, whether it's Deputy Bueno, whether it's me. We all have the right to gather and disseminate information to other people in our communities or across the world as the technology will permit. Whether it was the printing press hundreds of years ago where the church was trying to suppress the printing press because they didn't want the information out there, to the modern day now.
Auditing Reno 911 did a great job articulating exactly why he is press according to the Constitution, why anybody is press.
Is your phone currently recording?
No, I'm looking at part of my argument here. Okay. I'm looking at NRS 4.360, which is denomination of court. Court always open where held. The courts held by justices of the peace are denominated justice courts. Justice courts have no terms and must always be open, period. Except as otherwise provided in this subsection. And 5, justice courts must be held in their respective townships. Justice courts are public venues.
There's no doubt about that. I don't need those sites.
And with, as we look at Fordyce versus Seattle out of the Ninth Circuit case, I don't know if you're familiar with that, or if we want to look at the state of Nevada and NRS 171-1233 and what our legislative intent was when the Nevada legislature codified that, and I believe it was the 2021 session where Governor Sisolak signed it into law. The intent of our legislature is to record and document and disseminate information about our government, specifically law enforcement, to the public. Fordyce versus Seattle, people in public were going out and recording a riot, if you don't know about that, back in the 1990s.
So hang on a second. What is your benefit of your recording device as opposed to obtaining a copy of the court's?
I controlled my recording device. For example, I requested a record of my criminal trial where Deputy Bueno illegally arrested me and hotbox tortured me on a 95-degree day, closing the windows.
Hang on a second. That didn't go to trial, did it?
No, the case was dismissed.
Hang on.
The case was dismissed. I would reference, Thompson versus Clark out of the Supreme Court of the United States. I referenced that in the documents that I gave you. But unless he gets a conviction, you've done a malicious prosecution is basically what the Supreme Court of the United States has said.
Okay, and I'm not here to litigate whether it was
but as far as
truly appropriate back at the prison or not. I'm here to look at, regardless of the truth of that, I guess there's an angle on lawfulness, but regardless of that, whether an order, protective order, is needed.
Let me get back to your question, sir.
So the recording, that's what I'm getting at.
Right.
Like right now, like if you were recording, your camera is going to be in a fixed position. It's not going to be being moved around. The courts are automatically picking up mics and moving. So I guess why the additional extra and different?
I just got a copy of the court record for my criminal trial, and I ordered that. I paid the court some money. So number one, in this one, I don't have to pay the court money for a recording that I already own. But number two, on the recording that I paid for from the court, there was a recording of the video, but there was no audio. So I paid money to the court for a video recording, but no audio, so I can't use it.
It was a glitch that prevented something. You want a backup.
So I want a backup, so I don't have any glitches, so I control the recording, and so I don't have to pay the court money for something that I can produce on my own. Without any interference, as I sit here, I can set up I brought a tripod, so if you need it to stand somewhere else, I brought a tripod that can sit on the table. I can put it wherever you want. It's an inanimate object that just sits there just like your cameras and documents the reality of what happened.
What if for backup and safety's sake, I allowed audio instead of audio and video?
If the court tries to offer you this and allow you to audio record and not video record, press further. You should be allowed to video record and audio record. Don't let them push you around and just get you to audio record. Don't let them try to compromise you out of your rights.
What are your thoughts on that?
I would rather have both so we can watch people's reactions, facial expressions, body language.
But you won't see that. I'm not going to interrupt the proceedings. There's not going to be a moving of it to individuals.
Well, that's what I'm saying, Your Honors. If I can have a recording, I can put it and I can, on a video, I can see what those interactions are that it picks up in the amount of screen that you allow to be recorded. So I want the video so I can see those body, those facial, those reactions, along with the words that people are uttering. That way you can see both, and that way when I do disseminate the information to the public can have a more clear view of everything, and they can make up their own decision. Deputy Bueno has accused me of altering things and editing things out that weren't, and I'm going to disagree with that, and what I'm going to do after I go home from now is I'm going to go repost his entire videos without the dead space taken out, where the law enforcement edited out their own stuff, and I'm going to post the entire videos again, and that way what he's represented here will be in the public. My only goal with doing this, I'm a business guy. I've been running a business in our community for decades. My family ran businesses. I got off my butt, got off from behind my desk, stopped running my business, risked my business to record government because I've been damaged by government officials. The only way that I know to fight back is to exercise constitutional rights to gather and disseminate information about the wrongdoing that I see in our state.
Hang on, I understand that. That's not an issue for today.
So that's my goal. I've been accused of not being a journalist. So what is the definition of a journalist to the court? The definition of disseminating information, the Supreme Court's looked at that. As long as I'm disseminating information to the people, I'm a member in exercising my constitutional right under freedom of press, Article 1, Section 9, Nevada Constitution.
Okay, now regarding the timeliness of this, your written work says you knew of this at 10 o'clock yesterday. The deputy, or whoever the representative is, Kristen Marquez, indicates 4:32. When did you become aware of this hearing's potential?
About the time that, was it Marquez? About the time referenced by Marquez that you just mentioned there. If you do want to go look at my channel, I did post a audio recording of her telling me when this was, so I've got that firmly documented as to when that happened. So
Over the phone?
Yeah, she called me on the phone, and I recorded the phone conversation.
Did you ask her if you could record it?
It was stated in the very beginning of the phone call that this was a recorded conversation for Nevada law.
Mr. Rebar,
I misread your request. I thought you were notified at 10 o'clock yesterday.
No.
You were notified the hearing would be about 10 o'clock.
Yes, sir. Yes, Your Honor.
And
I believe he's posted videos of the contrary to that, Your Honor. He had business cards when they were attempting to serve him as residents. He was avoiding service and tried to be served in Carson City. Washoe County couldn't cross the county line. He posted a video, another defamatory video before 4 o'clock yesterday. That's a matter of record as well. So again, he's distorting the facts.
okay, so hang on a second. I've talked to you on these preliminary matters, and some of it is factual that I need to make decisions based upon it, and I neglected to swear each of you in. So would each of you please raise your right hands?
Whoopsie daisy, forgot to do my job correctly, so we'll just go ahead and do it now and change it up a little bit. Even pay attention to how casually this is done. Like, it's such a joke to me how we go through this ritual of raising our hand and repeating these words, and I solemnly swear, and come on, man, you know, has anyone ever been in a courtroom and raised their right hand and said, no, I don't swear to tell the truth?
Do each of you swear or affirm under the penalty of perjury that the testimony either that you have given, the answers you have, or statements you have made since the beginning of this hearing, and any information or testimony you provide from here on out either was the truth or will be the truth?
So help me God.
So help me God.
Okay. Mr. Rebar, did you know that law enforcement was trying to serve you with something prior to 4:32 or 4:23 yesterday?
Everything is posted online as far as my experiences of what happened.
That's not the answer.
I'm answering the question, sir.
So did you know they were trying to serve you with this or anything else?
Washoe County Sheriffs contacted me by phone after they left a business card taped to my gate.
When?
They left a business card taped to my gate, I think, was it Wednesday last week? I don't want to specify the exact date, I forget.
Did you ever call on to see what's up, or did they talk to you?
No, then Washoe County called me in the morning, it was about 7 o'clock in the morning, and I told them, they said, hey, we need to serve you. I said, okay, I'm going to be out and about. They said, well, where can we meet? And I said, well, I can be at my office in Carson City, and I believe there's a video online, so we can watch that to make sure that what I'm saying is accurate as I recall. I said, meet me at 9 o'clock. It was either 9 or 10 o'clock. And then they called me up later that afternoon, and that video's online too, that said that they couldn't come to Carson City to serve me. And I said, well, I can still come to Washoe sometime. And they said, no, we're going to give it back to the Carson City Sheriffs. And then the next day, Carson City Sheriffs came into my office in Carson. I wasn't there, and I told my office, I said, give them my cell phone number, have them call me, and I'll set up a time to meet them. I told them if they wanted to come serve me last night, that they could come serve me at my home in Washoe Valley. They said that they wouldn't do that, and I said, I will be at the courthouse this morning at 9:30 because I don't want to ignore the court, and if you're looking for me, I'm going to show up. I said, come serve me at 9:30 at the courthouse. I'll be here to check in and make sure I'm doing all the stuff right. And so far, I still haven't been served. I'm not trying to hide from service. I publish the videos that show me making the appointments, trying to be there, and then the government cancels the appointments because for some reason they can't come serve me wherever I'm at.
Do you have a copy of the complaint or the application? Yeah.
Your bailiff gave me a copy of, so I just got this and I've had a few minutes to read through it, but I haven't had any time to thoroughly deal with it.
I believe
your recording that you're asking for is recording, not live streaming, is that correct?
I think I was live streaming one of.
What you want? You're saying you want cameras in the courtroom. Are you wanting live stream, or are you wanting simply to record?
I'd like to do both if I can. But if I could live stream, that would be even better. That's more real. As Deputy Bueno is discussing, he's concerned about editing. If I'm live streaming, there is no editing. It's just live. And I do a lot of live streaming.
Your Honor, it goes beyond his editing. It goes all into his content and his false representations of everything that he posts. The video that he posted most recently yesterday that he's referring to was titled "Coward Deputy No Bueno Filed a Restraining Order," and then without any type of check or balance has free license to commit libel.
When was that posted yesterday?
That was yesterday afternoon, I think just after 3 o'clock. He was aware. He also filmed himself making contact with the servers that were trying to serve him. But the point that I'm trying to make about the videos and the camera...
Hang on. Describe that. Filmed himself with people trying to serve him.
Can you speak up one more time?
You're stating that he filmed himself when people were trying to serve him. What do you mean by that?
He filmed another monologue outlining his opinions on the service of him obtaining a business card from his residence, and then went on to describe roughly what he just was trying to talk about as well.
How long ago was that up? Was it yesterday or?
It was yesterday afternoon before 4 o'clock. I was in a meeting with admin about that time. But again, sir, the point being is that Mr. Rebar has clearly gone beyond his First Amendment right when he has knowingly produced libelous slander and defamation against myself. He's done it in this courtroom today when he talks about torture and false arrest. He's been provided with investigations from the sheriff's office when he made a complaint of torture.
Yes, like those ultimate underlying decisions, maybe they are, maybe they aren't, but there's not been a finding and an adjudication of them yet. And again, my issue right now is just recording, not recording. Looking at the statute in question, I have some fairly broad discretion, or the rules, I should say, have some fairly broad discretion in this area. The rule does, hang on a second, using my phone for the rule. And this is 230 subsection 2, a presumption that the courtroom proceedings are open to the public. That to be precise, there's a presumption that all courtroom proceedings that are open to the public, and this is, I'll note that no one's here. No one cares enough to come down, apparently, despite their interest online.
It seems like the judge is kind of talking crap there. Like the judge is suggesting that there's not public interest in the case. This is a great time for me to point out why it's so important that people go to other people's court hearings. If you have a friend or you know a YouTuber in your area that has court on a specific date, show up to that court. Just go and sit down and show your support. Let the court know that this person is not alone. Let the court know that there's eyes watching what is being done in that room.
Are subject to electronic coverage. There's an underlying presumption that there should be, or it should be allowed, and then I have to make particularized findings under that subsection, whether to allow it in whole or in part. And then it goes through the factors that I've asked about. As far as the definition of reporter, it is extremely broad. It appears to be posting on all sorts of topics, according to what I've heard. This matter is a little different than many of the others. He's got, appears to be a very personal interest in axe to grind in this case. Given his arrest, as opposed to things that might have happened in the other cases or situations just briefly described to this point. The timing of the request, according to the rule, needs to be 24 hours in advance. There's reason to believe that Mr. Rebar knew this was coming well in advance. He wasn't served with the exact nature of it. Washoe deputies not wanting to go into Carson deputies or process servers not wanting to go into Washoe. The schedules of both parties apparently conflicting. I'm not going to even speculate on the motives behind either party, but the 24-hour request in this case is basically, hey, I didn't get the exact service and the notice of what it was until 4/23. And then if I believe Deputy Bueno, there was already posts online knowing what they were. We're looking at strictly, should this recording be allowed, the 24-hour requirement. Hard to say under the two different versions here that there was an active avoidance of service. There was short notice. I do have the authority to waive it or shorten time.
I'm glad to see in this case the judge didn't use the technicality of the 24-hour notice to block this man's right to record in the public proceeding.
The bigger questions in my mind are the factors I'm supposed to consider: the impact of the coverage, the privacy issues, the safety and well-being of individuals, the detraction from the dignity of the proceedings, and the type of coverage and the adequacy of the facilities. Here it appears to be a phone. Is that correct, Mr. Rebar, that the request is being made to use?
No, I've got multiple tools, but I've got a professional camera, tripod, and other tools to professionally record and document and disseminate information.
This one is a difficult decision in that the underlying allegations include posting and alleged editing of material that has potentially caused issues for the applicant. In the application, references to others being riled up and reaching out to him, purportedly stoked by Mr. Rebar's postings is the argument. The detraction from the dignity of the proceedings or the party's ability to not be distracted in answering in process is in my mind when it's over and above the court ones. Again, the court ones record by video and audio. The feed automatically adjusts between the players to capture. There's been evidence that in the past, audio recording has failed and video only has come through for whatever reason. That is always a potential, as this is at the heart of the matter and likely to be posted and likely very duplicative of the record the court makes that may fail from time to time, but is unlikely to fail. I don't think that I can say that Mr. Rebar is not a reporter. The timing gives me some concern. The distraction of the additional gives me quite a bit of concern. The delay, like I said, cuts both ways, but what I'm going to do is allow a supplement of the record. If Mr. Rebar wishes to turn on the camera, have it at me, collect me and the voices of the parties, that can happen. And I'm finding under the subsection 2 of Rule 230 that is reasonable despite the late request and is the least distracting to the parties, especially given that this is the underlying, one of the underlying allegations or issues in the case. If you want to set that up and point it at me, feel free.
We all know we shouldn't have to fight this hard to get this kind of treatment, to be able to pull out our own recorders and record what's happening in our court sessions, especially when it involves us. We should be able to do it to any court proceeding, but especially when we're the ones being prosecuted and defending ourselves, we should obviously be allowed to keep our own record of what's happening to us.
May I live stream, Your Honor?
No.
I have a question, Your Honor.
Yes.
If this order is granted and he uses those videos to further drum up more threats against me, then that would be understandably a violation of that order. And I could file on violation of that order by further posting those videos and incurring those threats.
Well, there may or may not be increase of harm to you. There may or may not be libelous content from either party's perspective, but I guess I'm not sure what you're asking. What you're saying is if he posts the recording of me and the audio of the hearing.
You've been watching the court's video the whole time. Listen to the static that's in it. Listen to the low quality of the audio compared to his professional camera that he put on the desk after he was told he was allowed to. Pay attention to the quality difference. Among all the other reasons that he gave to record your own video and not rely on the court's video, I'll play it back to back here so you can get a good comparison of the two sound qualities and video qualities. And we'll watch the rest of the video from his videos since the quality is obviously so much better.
To do what with it?
Very shortly, there'll be a cease and desist from my personal injury attorney to remove all content from YouTube.
To do what with it?
Very shortly, there'll be a cease and desist from my personal injury attorney to remove all content from YouTube, as it's libelous and damaging, and it was proven such. In order for him to further where he's going with this now, my concern is obviously that this recording is going to be used in the exact same way that he's been stalking myself and my family.
And if there's some wrong that flows from that, there's consequences that are potential for it. But I'm allowing it. I am not ordering that he can or can't post this proceeding. That Mr. Rebar does at his own risk, like any person who posts anything under any circumstance. He's allowed to record the court and audio of this proceeding, the other parties talking. That's been my ruling. We haven't, just for the, I'll call it the record, so to speak, the only record according to statute is the court's formal one. But for the sake of completeness for Mr. Rebar, when we started, we have been talking since the beginning of this about his initial request, whether or not he could record the proceedings. I have examined Rule 229, 230, and the like regarding his ability to record. I have authorized a limited ability to record to protect the dignity of the proceedings and the individual's focus and ability to not be distracted. The limitations that I have posted or ordered are that the camera, again, can be posted at me or directed at me. It can record audio of anything else in the courtroom. And that's the extent of my ruling. I'm not, again, ruling whether or not he can do anything with the recording. The next issue to address before getting to the merits of the matter are there was an opposition to the hearing. My understanding after reading it is that Mr. Rebar is asking for a continuance.
Thanks for watching, everybody. I hope you learned something, or at least enjoyed watching this small victory. Let's make recording in the courtroom the expectation instead of the exception.